Hello dear students, my name is Anil Today I am going to discuss a topic related to a Supreme Court petition filed by a member of the Sharad Pawar faction of Maharashtra. His name is Jayant Patil, and the case name that has been filed before the Supreme Court through SLP, specially petition. I would discuss about SLP later. Is the Jayant Patil versus Ajit Anantrao Pawar, and it relates to the disqualification of members of the Ajit Pawar faction, where the petition says that the Speaker, Mr. Rahul Narvekar of the state legislature, that is a state assembly rather, because Maharashtra has two houses. So, State Assembly, Mr. Rahul Narvekar, the Speaker of the State Assembly, is willy-nilly. In fact, he does not want to disqualify the members of the Ajit Pawar faction. So, either direct him to do so or do it yourself. This is the specially petition filed by Mr. Jayant Patil. I would like to tell you, my name is Anil. I teach PSIR in optional and polity, governance, constitution, social justice, IR, internal security. In GS, I am also going to start a class for the students of the Reserve Bank of India Grade B officers, preparing for the Grade B officers for prelims now. And after some time, we would not wait for the result. I would discuss Indian economy, public administration, financial management, and other aspects of the GS sections which figure there in the mains examination, that is written examination. In fact, it is followed by an interview of 75 marks. Prelims is of 200 marks, while the written examination is of 300 marks and interview is of 75 marks. So we would be discussing here the preliminary ones. In fact, first, because that is the biggest hurdle for the students preparing for any exam, where three stages are held. For example, UPSC also holds preliminary examination, which is a screening test. Its numbers are not finally counted. I would like to tell you that it does not have any impact on the ranking, but certainly it gives a ticket to the written examination. It is in fact an entry point to the written examination, rather you can say. Here, now let us focus on our current topic today. Today, the Supreme Court has issued notices to the Ajit Pawar factions on a specially petition filed by Mr. Jayant Patil, a prominent member of the Sharad Pawar faction of Maharashtra, who in fact leads the NCP, Nationalist Congress Party. It has now two factions, as you know, after its split. Its splinter group is called Ajit Pawar faction of the NCP, and the Election Commission, after looking into the matter on the strength of the Ajit Pawar faction, granted the original election symbols of the NCP to Ajit Pawar faction, and also to other recognized it, in fact to other aspects it granted. For example, it recognized the party as the original party. However, recently, after debacle of the BJP in the Lok Sabha elections, the Jayant Patil leaders, I would like to tell you, he belongs to Sharad Pawar faction. So Jayant Patil like leaders, in fact, started rethinking about their strategy, because they felt that in days to come, the BJP might not be a good choice for them to join the political party. While Ajit faction remained wholeheartedly attached to the BJP and is a part of the NDA in Maharashtra, where Eknath Shinde is the chief minister. Still, its some members are reported to be thinking of changing the side to again Sharad Pawar faction. In fact, a few leaders also returned to the faction, Sharad Pawar faction. So, in the light of such a developments, Mr. Jayant Patil has filed as an SLP before the Supreme Court, requesting it to direct the Speaker of the State Assembly to take a decision regarding disqualification of the members of the Ajit Anantrao faction, Anantrao Pawar faction rather. I would like to tell you that Ajit Anantrao Pawar, or in short Ajit Pawar, defected from his uncle Sharad Pawar last time, and together with him several other leaders who are earlier close to Sharad Pawar also defected to the new outfit, that is to the NDA in the state, that clobbered together Eknath Shinde led Shiv Sena and Ajit Pawar led NCP. I would like to, despite being the biggest chunk of the coalition, BJP choose to play a second fiddle to Eknath Shinde, who is now the chief minister of the state, and he is a breakaway faction. He is heading or leading a breakaway faction of the Shiv Sena, where more than 40 members, in fact, reported to have joined the NDA there in Maharashtra. I would like to tell you, after debacle in the state, in fact, Sanjay Raut and Uddhav Thackeray made several comments against Narendra Modi, but that is a political tutu meme. I am not going to involve myself into that one. I would like to tell you, I would remain confined to my discussion on the defection issue related to Sharad Pawar and Ajit faction in the state of Maharashtra, where Sharad Pawar faction has requested the Speaker, Mr. Rahul Narvekar, to disqualify, not some members, to disqualify members of Ajit Pawar faction. The term "some" is missing there. It has not been used there. I would like to tell you that the term members appear there, and accordingly, Jayant Patil has filed his SLP, specially petition. Today, I am going to discuss all about the Anti-defection law or Anti-defection Act. I would like to tell you that it all started in 1960s and 70s. In fact, in 1967 and 1971. Between 1967 and 1971, when two elections. In 1967, in fact, elections to the state assemblies were held together with the Lok Sabha. It was the last time when state assembly elections and the Lok Sabha elections together coincided. Thereafter, in fact, due to the dismissal of several state governments, elections had to be held midway, which in fact made it a regular affair since then. And at regular intervals, elections to these states are held from time to time. For example, this year, in fact, elections to Haryana, Maharashtra, and a few other states like Jharkhand, in fact, are going to be held. I would like to tell you that this has become a routine since 1967. That's why Narendra Modi, the present Prime Minister of India, wants that such things should not happen, and one nation, one election should again begin, because he thinks, in fact, the reason behind this one is expressly expressed by Narendra Modi and former President of India, Ramnath Kovind, who is heading a committee, that the reason behind this is, in fact, not to disturb the government. In fact, the government remains preoccupied with these elections and does not concentrate on the works or functions or the schemes or policies that it is likely to announce or likely to implement. In fact, the reason behind this is not this. In fact, the reason is something else which has not been said by the government or Narendra Modi. The reason is that Narendra Modi thought that in terms of the popularity, he is ahead of other leaders in India. That's why if elections are held in states simultaneously with the Lok Sabha, perhaps it would make easier for the BJP to roam back to power in various states. I would like to tell you, since this has not happened this time, let us see when it happens. But for the time being, we are concentrating on the topics we have taken up. That is, Jayant Patil, a prominent member of Sharad Pawar faction, has filed a petition before the Supreme Court. The petition is SLP, specially petition. I would discuss about SLP later. Under Article 136, it is filed before the Supreme Court. However, it cannot be filed on the decision of the against the decision of the military tribunals. I would like to tell you our international agreements are treaties, in fact, which are exclusive privileges of some other bodies, but it can be filed against the decision of the lower courts, high courts, whatever court tribunals, in fact, before the Supreme Court, and Supreme Court accordingly can decide the matter by taking up the matter in its own hands. Now, let me discuss it. So, an SLP has been filed by Jayant Patil, a prominent member of Sharad Pawar faction, requesting the Supreme Court that it should direct the Maharashtra State Assembly Speaker Mr. Rahul Narvekar to disqualify members of Ajit Pawar section. As I told you, the term "some" has not been used in this one, making it conjectural. One can conjecture or one can indulge in a good amount of prediction that even Ajit Pawar is subject to disqualification should it happen. I would like to tell you that I am going to discuss the disqualification issue besides discussing other issues also. Now let me start this. I would like to tell you that in 1967 a member of the State Assembly, Mr. Gayalal from Haryana, changed a political party. In fact, changed several political parties 3 times a day, making prompting media to term it or to nickname it Aya Ram Gaya Ram, or to raise the slogan Aya Ram Gaya Ram, means Ram comes, Ram goes. So nobody knows when ex-member would join another political party. Today he is seen in one political party's camp, but tonight he might decide to join another political party's camp, thus making the government of the day unstable. In fact, the instability became the hallmark between 1967 and 1971. I would like to tell you, during the in between these 2 Lok Sabha elections, I would like to tell you that out of 4,000 state legislators, members of the state assemblies, nearly 50% changed their sides or joined other political parties. However, they were elected on the ideology of one political party, but after election, they joined other political party. The biggest beneficiary of such a turncoat was the Congress itself, led by Srimati Indira Gandhi, while 98 members of the Congress left the party to join other political parties. In fact, 419 members of other political parties joined the Congress. In sum total, I would like to tell you, the Congress was the biggest beneficiary this way. So the Congress was kept mum, but in 1967, Y.V. Chauhan committee, in fact, a committee was set up under the leadership of Y.V. Chauhan, Yashwant Rao Chauhan, I would like to tell you, and it recommended that such factions need to be controlled through laws. However, a law was to be passed, but it could not be passed by both houses of parliament, and it fell through. That's why the responsibility finally came to the shoulders of Rajiv Gandhi, and he in 1985, after his brute majority in the Lok Sabha and riding the crest of popularity, he got it done through 52nd Constitution Amendment Act in 1985, adding Schedule 10 to the Indian Constitution. For the first time, a political party was constitutionally recognized. I would like to tell you its para 2 and para 6 and 7 or para 4 are very important. Out of its 10 paras, 2, 4, 6 and 7 were very important. In fact, then the difference was made between the split and the merger. That one-third members of a political party, if they decide to walk away from that political party and engineer a split, then the split could happen. But if two-third members of that political party decide to walk away from that political party or engineer defection, then they could merge their identity with other political party. In other words, for merger, it was decided that two-third majority was needed, and for a split, one-third majority was needed. The split of a faction was to be recognized as unattached members, while the two-third members that decide to walk away from a given political party, in fact, they would either merge the identity of themselves while merging themselves with other political parties and taking its symbol and name, or they could invite other political parties to get merged itself into them, and this way use their symbol and name. So both way it was allowed. It is called 52nd Constitution Amendment Act. For nominated members, it was decided that if beyond 6 months they decide to join a political party, they would be disqualified. For independents, it was decided that they would be disqualified from the very beginning. Should they want to join other political party, they first have to resign their present position, and thereafter they can decide to join a political party. However, it was given more teeth by the 91st Constitution Amendment Act during Vajpayee's reign in 2003 by adding 3 more provisions to this one. First one, and in fact split and merger both had been recognized the same. Two-third in fact had been recognized as necessary number of members either to split or to get merged. I would like to tell you, in fact, only one aspect was recognized, that two-third majority is needed. Now this is being done. Secondly, it was also decided once it is qualified in the same tenure or term, the same member can't stand as minister unless he is re-elected from his constituency or absolved of the charges by a higher authority or higher court. I would like to tell you that this is the second one, and third one is that the strength of the Council of Ministers can't cross 15% strength of the Lok Sabha, 15% strength of the state assemblies. Except I would like to tell you, it does not apply to local body elections, nor does it apply to union territory where assemblies are there in Delhi and in Puducherry. In fact, there 10% members could be appointed as ministers of the total strength of the assembly. In other words, if Delhi has 70 member assembly, if Delhi is 70 member assembly, then only 7 members could become the ministers. In order to reward other members, Kejriwal ji has in fact invented a device in 2015 after being re-elected, as the Chief Minister of Delhi, that secretary ministerial members could not join the council of ministers, but certainly could join the council as assistant to such ministers as secretaries. In fact, there is a provision of in several states there is a provision of being appointed. MLAs are appointed as secretaries, and secretaries also constitute the members of the council of ministers. So, but Delhi High Court and later the Supreme Court frowned upon that. So, in fact, the sitting chief minister of Delhi could not do that one. I would like to parliamentary secretaries, as they are known as parliamentary secretaries. Even if in the state assembly they are known as parliamentary secretaries. It does not matter whether they are elected in the center or in the states. Their name nomenclature is parliamentary secretaries. They are generally considered an assistant to the sitting ministers, and they enjoin in certain books. In fact, the strength of the council of ministers also include parliamentary secretaries. I would like to tell you, they are not bureaucrats. Hence, they are generally MLAs, and hence the defection law, by if you go by the decision of the Calcutta High Court and several other high courts, I would like to tell you that they have said that since they are also like ministers, hence a disqualification applies to them also. So later, Kejriwal ji decided not to proceed ahead, not to go ahead, not to move ahead. I would like to tell you, Anti-defection Act 1952 has 10 major paras. One para, especially second para, and I would like to tell you sixth para came into controversy in 1992 when Kyoto Holohan versus Jechelu case was being looked after by the Supreme Court. In fact, in the Act, it has been laid down that the decision to disqualify a member of the assembly or parliament, in fact, should vest in the presiding officer, and his decision should be considered final. However, the Supreme Court says, when in the Jachilu case, that whenever the presiding officer of a house, in fact, takes up the matter and looks after such matters, in fact, he acts as a head of a tribunal. In that case, or that house, in fact, resembles a feature of a tribunal, and in that case, an appeal could lie before a high court or the Supreme Court from the decision of such a tribunal. Accordingly, Speaker's decision could be challenged before the Supreme Court or even before the High Court, as per the decision of the High Court earlier in Kyoto Holohan versus Jechelu case in 1992. I would like to tell you, Justice J.S. Verma, who is no more right now, then he was the judge of the Supreme Court, and he delivered the judgment, majority opinion, saying that in Jechelu case, in fact, whenever a speaker, either of the assembly or of the Lok Sabha or presiding officer of the Rajya Sabha, does this sort, in fact, he or she acts as the head of the tribunal, and its decision could be challenged before a superior court, either before a high court or Supreme Court. Generally, before it is challenged straightway before the Supreme Court, because it also involves the question of fundamental rights of equality. I would like to tell you that this way things have panned out. Hence, you must remember the Anti-defection Act of 1985, which was added to which was done there through 52nd Constitution Amendment Act, and further it was amended in 2003 by 91st Constitution Amendment Act. And as I told you, Three more stringent clauses were added to this one, or clauses were added to this one. And I would like to tell you its present status. Recently, you saw in Himachal Pradesh that three independent MLAs or four independent MLAs who decided to join the BJP, perhaps three. They first resigned and later fought elections, by-elections in the state assembly, but unfortunately two of them had lost the election. One was elected there. I would like to tell you, out of the four state assembly seats, three had been won by the Congress and one by the BJP. However, similar things happened in several other parts of India. In fact, last year and in 1992, sorry, 2022. I would not discuss more about these ones. For this, in fact, I would like to end my lecture. Thank you for watching this.